Someone make it make sense.
Probably a couple.
Alrighty, guys, we are back for part 2 of covering all of the latest filings out of Ada County. Bryan Kohberger. We made our way through many of these documents last time. We covered, on part 1, we covered the motion for leave, motion for Frank's hearing, and the motions to suppress for the IGG, Amazon, apartment, and Apple. So where we left off is with the arrest warrant, which is where we will be starting today. So without further ado, let's jump right on in to the motion to suppress the arrest warrant. And for those of you who didn't see part 1, what we've seen so far in these motions to suppress, there's a lot of material that's sort of like copied and pasted, if you will, where there's just things that are factually the same. So some of that stuff that I will skip over if we've already covered it in part 1, and we'll kind of focus on more so the specific details that are different for each of these motions to suppress. So, all right. Well, this right here stands out, right? Submits the following memorandum in support of his contemporaneously filed motion for an order suppressing all evidence gathered by law enforcement as a result of his arrest. So this is a motion to suppress. What this says to me, contemporaneously filed motion for an order. Let me see. So that has not come in yet. It looks like that is going to be coming soon because it's saying contemporaneously filed motion for an order suppressing all evidence gathered by law enforcement. So that has not come in yet. So, but we could be seeing that any day now, especially since now it's the beginning of the week again. So I'll keep an eye out for that, but that's what they're going for. And that makes sense, again, based on what we went over in part 1. The problem is like the reason that they're saying this, right? All evidence gathered by law enforcement, because they're alleging that literally all of the evidence gathered by law enforcement is fruit of the poisonous tree for various reasons that we're learning about as we go through these motions to suppress. You know, that's also what the Frank's hearing is going to be about as well, right? Because if his rights were violated with due to the searches that were done, right, then anything that's obtained through those searches, right, then that is thrown out. So, and we did cover that Frank's hearing on part 1 as well. So, and for anyone who didn't see that, everything is timestamped too for each of the different documents. So, okay. So again, these issues tend to be the same for each of these motions to suppress. And usually there's one thing that's different, and that would be probably here. Information about the client's locations taken from his phone must also be excised due to, actually, I think that's the same also. Okay, so this is the same. This is the same as what we've seen before. The basic facts Corporal Payne used to support the arrest are discussed in detail in a separately filed motion pursuant to Frank's, like I just said, Frank's v. Delaware, right? We covered, and we did cover, when we covered the Frank's motion, we also covered this case law as well on part 1. They are incorporated without repeating. So here we have the SWAT showing up at his parents' house. This is, again, some of this is the same as what we've seen. Interesting here. Okay, check this out, guys. At the station, Mr. Kohberger was processed, during which police collected information about his person. Finally, during interrogation, before requesting an attorney, Mr. Kohberger made statements to interrogators from the Idaho State Police and the Moscow Police Department. Whoa. Now, we had heard a whiff of that, but again, to me, it doesn't really count until you have it in writing, you know, verified. Like, this is, now it's verified that that has happened. I was under the impression that maybe he made a statement in passing. I did not think he was interrogated. I thought he would have said, nope, I don't want to talk to you. or I don't want to talk to you without an attorney. And then they were like, well, whatever, what's the point? Like, I didn't think that he would have done that. Wow. So he was interrogated. I did not think he was actually interrogated. Wow. Both the Idaho State Police and the Moscow Police Department. Incredible. That's blowing my mind right now. Okay. Argument. This court should apply Idaho's exclusionary rule and law to this search. So this came up again a little bit in part one, talking about the trouble when you've got a multi-state investigation, right? And which jurisdiction will control the validity of the arrest warrant, or in previously discussed the search warrant, because it does vary by the state. And as we've mentioned, Idaho tends to have a different standard than some of the other states. It's actually been phrased, and it was in quotes several times on part one, Idaho's uniqueness, it would say, so that they actually have a higher value in terms of personal privacy. So there's, in other words, that affects a reasonable search and seizure standard. So, but again, what they're saying here is, well, are we going to use Idaho law or Pennsylvania law when we're determining the validity of the arrest warrant? Pennsylvania courts require a warrant for particular residence to go after a person police are aware has an arrest warrant. Without either type of warrant, an officer lacks this authority. State warrants have no extraterritorial effect. The use of an out-of-state warrant is ipso facto a warrantless entry. Thus, law enforcement in Pennsylvania could not rely on the existence of the Idaho arrest warrant to enter the home. Oh, okay. I see what they're saying. So it sounds like Pennsylvania law enforcement were relying on the Idaho arrest warrant to enter the home. Let's look at this footnote here. Where did it go? Note, there is an Idaho Court of Appeals decision that seems to be counter to the holding in Bradley. The Bryan court, however, never mentions or analyzes Bradley and does not appear to be aware of it. The holding in Bryan, I'm sure I'm not pronouncing that correctly, could not have overruled Bradley, and thus it remains the governing law in this state. Okay, so, and that's what they were referencing here. So finally, it must be said that there is very little daylight between the Idaho Constitution and the Pennsylvania Constitution. Both apply exclusion to a failure to knock and announce. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Again, this is that standard that was laid out in the Franks case law. Probable cause exists when, given all the circumstances set forth in the affidavit, there's a fair probability that contraband or evidence of a crime will be found in a particular place. Again, they've cited this before in the other motions. This is all, again, some of this is redundant, but you have to have an affidavit. And this was a key one. I'll read this one again because this is kind of crucial. Any discrepancy between the items for which there was probable cause and their description in the search warrant requires suppression. Finally, a criminal defendant may challenge the veracity of an affidavit used to obtain a search warrant. And the problem here is there's a lot of problems with this affidavit. Again, we cover this a little bit on part one. I think towards the end of the stream, for example, Corporal Brett Payne copied and pasted statements from other law enforcement officers' affidavits and put them into his own affidavit, which is supposed to be a sworn statement of his, right? It's his sworn statement, but a lot of it was taken from other people's sworn statements. That's just one of the many issues that sort of came up. But okay, so we've covered this, the preponderance of the evidence. An omission of exculpatory facts is material only if there is a substantial probability that had the omitted information been presented, it would have altered the magistrate's determination of probable cause. And again, this is relying on the IGG because that's how they first got to him, right? The IGG is how they got to him. And they're contending that it was unconstitutional because that counts as a search, right? Right. So Mr. Kohberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he has argued that there would be no investigation into him without that original constitutional violation. and this was in one of the other motions last time, but I'm going to read it again because it's important. It is not the results of the IGG that sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation in the shape of his eyebrows. Okay. Without IGG, there is no case, no request for his phone records, surveillance of his parents' home, no DNA taken from the garbage out front. We discussed the whole garbage issue a lot last time, and we delved deep into that. And what we found online, digging into it, was that from what it looks like, his parents' home in Pennsylvania is on a private road. Therefore, their trash being out at the curb, to my understanding, means it is not public. So I think that's where this comes in with the when they're saying it's unconstitutional, right? Because essentially, if it had been a public road, yep, it's fair game, right? Once that trash is out on the curb. But because it's a private road, therefore they would need a search warrant to get that. And I think that's where the problem lies, is that without a search warrant, they should not have. It was unconstitutional for them to have gotten to. They shouldn't have gone into the garbage, right? Because it's a private road. So they're referencing here. Shout out to Need Some Z's. Glad you're here. We're right in time for the garbage. No DNA taken from the garbage out front. Because the IGG analysis is the origin of this matter, everything in the affidavit should be excised. I mean, all of this makes sense in terms of just looking at this logically and just the chain of events. What's interesting to me, though, is that it seems like if this was as obvious a problem as it seems, it would be reasonable to believe that this would have been dealt with right off the bat as soon as he was arrested, as soon as his defense team was brought in, and that this would have been, thrown out. Like, it just seems like, I don't know how it has been going forward with all of this being the case. So anyway, all right. Information about the client's locations taken from his phone must also be excised due to being gathered from an invalid warrant. And there's the conclusion. So next up, and again, it really always just comes down to that fruit of the poisonous tree, because the IGG is what led them to him and was the basis of everything else that they then were able to obtain. It's all that fruit of the poisonous tree, right? Okay, so not necessarily. What do you mean not necessarily? So now we have the AT&T first warrant, motion to suppress. And we've seen this in some of the other documents here where the search warrants weren't specific enough. So this says the search warrant fails to provide specific particularization of what law enforcement could search and seize in Mr. Kohberger's AT&T account. And as we know, the case law is very clear that you need to be specific about these things. It can't just be broad. They used that example, I think it was taken from case law, about like something like obtaining the entire haystack to look for the needle, right? And that's not allowed. So what was the not necessarily for? I feel like when you said not necessarily, it was when I was saying that I'm surprised that it wasn't thrown out earlier. If these things all look like if these pan out the way they look, is that what you were referencing? Right. I mean, that's for sure. Pretty much all the search warrants weren't specific enough. Yeah. And again, they're referencing here the IGG. Nothing in the warrant should remain. Okay, the affidavit for this is for AT&T requested all customer subscriber information, device purchase information, any email addresses associated with the account, call detail records, cell site information, cell site locations for all service provider cell sites, and other like GPS location information, it looks like. All text messages, cloud data. In the exhibit attached to the warrant, however, law enforcement indicates only wanting historical phone records between the hours of November 12th at 12 a.m. and November 14th at 12 a.m., as well as prospective phone records. So that's just reiterating what they just said. In this matter, Corporal Payne specified in his request that the purpose for gathering the information from AT&T records was to, quote, aid in determining the location of the 8458 phone and the white Elantra in efforts to determine whether the white Elantra is the same vehicle identified in the surveillance videos. Pursuant to Carpenter, to the extent that information was being gathered for the movements of the vehicle, Mr. Kohberger has a privacy right protected by both the Fourth Amendment and Article 1, Section 17. So I think what they're trying to say here is, like, if you're trying to get phone records to then track down a vehicle, that's different. Like, in other words, you would need, the vehicle would be a separate thing, right? Like, you would need, for example, if you're trying to get surveillance footage from video cameras or whatever, right? So in other words, if you're, like, that's how I'm understanding that, right? Is like it says here, being gathered for the movements of the vehicle. Yeah, I agree. So okay, back to the Fourth Amendment. This is all the same as the other motions. And then here, the search warrant fails to provide specific particularization of what law enforcement could search and seize in Mr. Kohberger's AT&T account. Okay, the Fourth Amendment and Article 1 and 17 of the Idaho Constitution do not permit a cell phone to be searched incident to arrest. Rather, the police must seek a warrant. A warrant, however, is not a magical wand that grants access to anything a cell phone contains. As the Supreme Court found, cell phones can contain enormous amounts of information that is private and may not be viewed by the government. Courts have long required that warrants be sufficiently particular to allow a government agent to know what may be seized, viewed, or searched, and what may not. I think this was included in one of the other motions as well. So yeah, it lacks appropriate particularization, as we've kind of discussed. The warrant and the affidavit are not only all-encompassing, they are duplicative, often repeating things to be searched and seized. The only limitation in scope is that the property be related to the homicides in this matter. The Idaho Court of Appeals have held the requirements of probable cause and particularity serve different purposes. Oh, and this was in one of the other motions. We did read this. I remember that part about the evil of the general warrant. Let's just see. Consider the particularities of what the court has held. If it is not listed in the warrant, it cannot be seized. But you may search to your heart's content for the things listed in the premises named. Then try and compare this to searching a cell phone. In the words of the Supreme Court. Oh, and this one was also used in the other. I mean, I think this is when it came to the iCloud data, because I remember this part about the horseback and flying to the moon. We covered that part. The court then found that the warrant failed the test in two respects. First, it left to the discretion of the investigator what was relevant to the crimes alleged. Second, it made no attempt to delineate the types of files that court could be relevant to what the police believed they would find in the particular case, evidence that the defendant had made an online search of his alleged victim's address. In those circumstances, there was no reason to go looking at videos and pictures. I remember this part too. I think some of this is exactly the same as what was in the iCloud one. Holy mackerel. Holy case law. The Wheeler case is important to this case, not simply for the concept of a temporal limitation on the information to be sought, but for the principle that the government must make the warrant as particular as it knows how to make it. In the case at bar, the government is investigating a quadruple homicide in Idaho. Does it make sense to see if there's some hint at wanting to fight someone from 2 years prior, 5 years, 10? What, if anything else, that may be relevant to the police knew? The K-bar sheath and the Elantra, for that matter, what of the victims themselves, their sororities and fraternities? The warrant could have specified what was to be seized, but it did not. The court in Wheeler condemns government attempts to cast too broad a net under these circumstances. This is from Georgia. Okay. To conclude, let's go here. To conclude, the warrant issued for Mr. Kohberger's AT&T account was unconstitutionally overbroad. Law enforcement had the ability. So that's the other key thing. What they're saying is you have to be as specific as you are able. So that's what they're pointing out here. Law enforcement had the ability to be more specific, both as to the content and the category of the data it saw, and it chose not to be specific because what it wanted and what it got was a general warrant. Therefore, everything found in search of the AT&T account must be suppressed. And this is back to the IGG. All right, cool. Done. Let's moving right along, guys. What is this one? Okay, cell phone. Okay, let me zoom in. So cell phone and USB file. Again, a lot of this is going to be the same. So I'm going to try to kind of go through and see. Okay, so after seizing the phone, FBI SSA Jeffrey Tanzola made a copy of the contents on a cell phone on a Seagate 2 terabyte external USB drive. Here and after USB drive. And then after that, it looks like Detective Mallory of the Moscow Police Department requested a warrant to search the contents of the USB drive, at that time stored at the forensics lab. This right here looks like a problem here with chain of custody. The affidavit for the warrant was signed by Detective Mallory. However, most of the information in the warrant was cut and pasted, from an affidavit originally bearing the signature of Moscow Police Department Sergeant Blaker. But according to Mallory, now the sworn statement of Corporal Payne. So this is what I referenced. We talked about this last time as well. This is I don't understand how they're doing this. They're giving these sworn statements in an affidavit that are cut and pasted, or copied and pasted from other people's sworn statements. I can't even wrap my head around it. So, okay, so additional facts related to the cell phone data are as follows. The phone was seized when Mr. Kohberger's house in Pennsylvania was searched. Data on the phone had already been extracted by the FBI. The search warrant for Mr. Kohberger's family home in Pennsylvania is also the subject of a motion to suppress. Yeah, and I mean, the thing is that I think it's also just to get as much information as you can. You know what I mean? It's about, like, they shouldn't be doing it, but of course it's going to benefit law enforcement to be shady in a sense that if they're making these overbroad search warrants, because then they could get more information. Like, that's the point of being specific, right? Because you have to know something exists to ask for it. But the thing with being overbroad is, like, they are hoping to maybe obtain things that they didn't know existed, right? So so whether or not it's to make a suspect fit, I think it's still unconstitutional, right? Even if it's just they're trying to get more information, like, that's not how it works. So, but yeah, the chain of custody, this is a problem with this too for these affidavits. So, a lot of this is the same. Again, IGG, again, also it's the same. We're going to go forward here. Okay, the search warrant fails to command law enforcement to search the USB drive. Interesting. So remember, the copy of the shit they got off his phone, they put it on this USB drive, right? The warrant in this matter fails to actually provide a command to search the USB drive. Oh boy. Oh boy. It states in summary, 1, there are grounds for issuing a search warrant. 2, there are grounds to believe the USB drive, quote, for evidence regarding the investigation, including, end quote, and then lists all possible types of data on the drive located in the MPD's forensic lab. 3, the command is made to search the premises, which is defined as the police station's forensic lab, for the property and seize it. Okay. The court relied on these findings to dismiss a post-commitment. Oh, that's discussing previous case law. In this case, however, there's no reference to the affidavit, only to, quote, proof, end quote. In Adam Chick, the court found the warrant explicitly referenced the affidavit. And then this has come up before. Additionally, there's no evidence that the warrant and the affidavit were attached to each other. That's another problem. The The search warrant fails to provide specific particularization of what law enforcement could search on the copy of Mr. Kohberger's phone contained on the USB drive. And this is a lot of the same. Okay, this is interesting. So it lists the following as possibly existing on the USB drive. Data compilations relating to or containing information indicating, suggesting, or related to violence, fight, hostility, and lists a bunch of other things. Records of communications, written text messages, etc. Contact stored location information stored in any cloud account, internet history, written and audio recorded notes, indicia of residency in the premises and the above items. To be clear, the government, which created an image or copy of Mr. Kohberger's phone, put it on a USB drive, requested and received permission to search that drive for roughly 15 types of data compilations. Aside from the communications device capable of storing electronic data it actually knew it contained. It then listed separately 8 things that are obviously included within the contents of the data compilation it already requested access to. Presumably the only reason for listing them was to get away from the only attempt the warrant made at limiting what was to be seized. Information indicating, suggesting, or related to violence, a fight, or mode of hostility for any of the same. The data compilation is too broad in that it makes no attempt at defining the type of file sought. The remaining 8 in that they make no attempt to define what is to be seized. And then here again, referencing the Idaho Court of Appeals, this has been included in all these other motions. So has this part. This is all the same. This we've seen before, the colonists, general warrants. Yep. This is all the same. I'm getting pretty familiar with the way this is going here with when they're copying certain things. To conclude, the warrant issued for Mr. Kohberger's cell phone, in its image state on the USB drive, was unconstitutionally overbroad. Law enforcement had the ability, to be more specific, but they chose not to. Everything should be suppressed. Bada bing, bada boom. Next up, Google. All right. I'm wondering if this is going to have some new information in it. There it is. Google. Okay. So Google data obtained from 3 warrants. That data includes emails, personal contacts, financial information, documents, PowerPoint presentations. Oh, interesting. Photos, IP addresses, and more. And they're referencing the Franks hearing again there. Okay, so there's some additional interest. So the search warrants are duplicative and failed to command law enforcement to search the Google accounts. Okay, yep. Fourth Amendment. So, all right. Subsequent to Mr. Kohberger's arrest, many warrants were executed. The detectives began to work Google warrants. And for anyone who missed it, because this was kind of early on in the stream, I'm still wrapping my head around the fact that he was interrogated. Like, we did not know that. I did not think he was interrogated. I thought he was going to just keep his mouth shut and say nope. But apparently he was interrogated by both Moscow PD and the Idaho State Police, and then at some point asked for an attorney after making statements, and then they ended the interrogation. So that was news to me. Again, to have that officially, like, now we know. So he obtained Google Warrant 1 on January 3rd, a search warrant for all data available in a Google account in connection with this email, which looks legitimate, right? Plus 2 phone numbers and an IMEI number. Mallory obtained Google Warrant 2, a search warrant for all data available in a Google account in connection with this email. So there's another weird email. I mean, looks to me like this doesn't look like a real, unless it's somebody has a crazy nickname or something. I don't know. No reference is made in the affidavit to a nexus between Kohberger and this one, BK 5781. Google Warrant 3 adds the email account BK 5781 at displays. I think that's a typo, and that's supposed to say DeSales. I mean, I know it should be DeSales. You know, it's interesting that they would make that mistake here. The warrants have no limiting language in the search and no justification for duplication. Google Warrant 3 references the warrant return only for the wrong email. Bryan Christopher at gmail.com instead of Bryan Christopher 1994. Interesting. Also signed by Payne references Bryan Christopher at Gmail and this weird looking one here. But the return or the receipt and inventory report, nothing about this one. And see, okay, so they did spell it right here. So DeSales. So this was supposed to say DeSales before too. This is particularly noteworthy because email communication between Mallory and Google reference Google not producing data on non-personal accounts, i.e. desales.edu. Mallory indicates, quote, they, as in DeSales, are going to be able to help us with their end of the process, so that should be taken care of, end quote. Yet, BK5781 at DeSales, oh, look, and now they typed it wrong again. Excellent. Being sarcastic. Found its way into the Google Warrant 3 without any nexus or explanation, okay? The information in the warrants was, again, cut and pasted from an affidavit originally bearing other people's signatures. That's problematic. The basic facts used to support these searches were listed in Exhibit B. So details about Google as a company and what it stores based on Mallory's personal knowledge, a request for any accounts associated with Kohberger for any time periods. Wow, boy, talk about overly broad, right? Jesus Christ. Kohberger was observed entering a CVS in Pennsylvania on December 16th. And his email account, Bryan Christopher 1994, and cell phone number was somehow obtained by law enforcement. What's interesting is just a second ago, hold on, they said this. They said that, oh, okay. So they were saying that this is the wrong email. Okay. I see. Okay. For Google Warrant 2, a new email is referenced having been found in Google Warrant 1 data return. And that's this weird looking email. Fucking hell. Also added was a high probability a VPN was identified in Google return from January 3rd. For Google Warrant 3, a new email, this is the DeSales email, is incorporated into the third warrant without any supporting explanation. I know. It's incredible. I know, right? I know. Here's the thing. They have to record that shit. They have to. It was filmed or audio recorded. It would probably both. They have to record it. It's amazing to me that this is the first time we've learned that officially. You know, like I said, there had been rumors that he had, like, my understanding was like maybe he said something in passing to somebody when they first arrested him. That was the extent of it, to my knowledge. I thought because of his background and all that, and he'd been doing, you know, studying different things, you know, related to criminal law and whatever, like, I thought for sure he would not have talked, you know, like, I thought there's no way they interrogated him. And there was no mention of an interrogation. It's amazing that has stayed under wraps. And now we know he was interrogated, but you know, that was recorded. And it's going to be interesting to see if the prosecution is going to try to admit that at trial. You know, sometimes they get thrown out. We've not heard anything about this, right? We've not seen anything like a motion to suppress the interrogation, or, well, I guess that was kind of included in that other document, but it wasn't specifically about the interrogation. It was just referenced. So, but we haven't seen like any litigation over this. Now, having said that, could things be done under seal? Sure. But usually you at least know that they've made these court filings, and then they say it's under seal, right? Like, in other words, you know they exist, but you know that the public can't see it at this juncture. So it'll be interesting to see, though, if there's going to be anything further about this, because you know the prosecution is going to try to get that in, and you know the defense is going to try to keep it out. So I'm just trying to think, when might we as the general public get to see it? And the first time potentially could be at trial, right? But at the very least, I would think after trial it would be released. Yeah, I know. That's a good point. All the BS. I know. They're supposed to be. I mean, they are supposed to be. So, having said that, if it's not recorded, they can't use it at trial, right? So that really is, you know, that would be motivation to record it, you know, for law enforcement, if you want to be able to use it at trial. So, okay. This is all the same as what we've seen before. And the same thing as what we've seen in the other, was failed to command law enforcement to search the Google accounts. There are no grounds for, there are grounds for issuing a search warrant. There are grounds to believe property is in this Google account. The command is made to search the premises for the property and seize it. The premises is Google LLC, but there is no incorporating language for the search warrant affidavit. This is all the same, this Adamczyk case law. This is all the same, no, not enough particularization. I'm getting better at saying that word. This we've already seen as well. And again, I've got a good feel for how long a lot of this, it's like a couple pages of the same stuff. Okay, now here we go, conclusion. So this is some of the same stuff we've seen, right? Again, it was overly broad. Therefore, it's more like a general search warrant. Yep. Okay, Julio, next up in line, we have the pen, trap, and trace device. Now, I have no idea what this is. I'm excited to learn what this is. I don't know what this is. So, this was referenced in one of the other motions to suppress, and I was like, what the hell is that? So we will learn. We will learn what it is. It has something to do with AT&T. That's what I'm gleaning here so far. I have no idea what this is. So the new information, this new information is including the affidavit for a new search warrant sought both for account information as well as a pen trap for Mr. Kohberger's phone. I have no idea what that is. Does anyone know what a pen trap is? Or I guess I can look it up. Is this, I just have never, I don't know what that is. Oh, okay. So it looks like it's a lower standard than the usual probable cause that you would need for like phone tapping, but I still don't know what it is. Okay. It's a device or a process that traces outgoing signals from a specific phone or computer to their destination. Okay. Also, it's also called a pen register. Okay. Or a DNR is also, it looks like it's also called DNR. I've heard that before. So, okay. It records all numbers called from a particular telephone line. Okay. All right. Now I got it. Excellent. So, interesting. So here we go. On November 13th at approximately 2:42 a.m., Mr. Kohberger's phone was, quote, utilizing cellular resources, end quote, that provide coverage to his apartment in Pullman, Washington. They support the idea that he left his apartment and went south. They supported the phone being off. This we've seen before, but I'll just read it again. They support at 4:48 a.m. that the phone is south of Moscow, Idaho, near Blaine, Idaho. The phone utilizes resources that make their way back to Pullman, coinciding with a white Elantra seen on some surveillance there. Similar data showing occurs at approximately 9 a.m. with a trip into Moscow and returning at 9:32 a.m. Wait, would that not be him going back to the house? Because didn't we read in one of the other motions that they said they believed he didn't go back to the house? Hold on. Do y'all remember that? I know you were there, Need Some Z's, because I was like, what? Because they were referencing the cell phone pings, right? Using the towers. And they said, 12 times before the murders and then the one time the day after the next morning or whatever. But then it said law enforcement now believes that he didn't make that last trip, something like that, right? But now, what is going on with this then? Isn't that's what that... Okay, we'll see if we find out. Did he go back in the morning or did he not go back in the morning? Here at stake are the records of a telephone account. The records the state sought included: 1, identifying information about the account. Okay, I'm not going to read all this. This is same as we've seen on other things and pretty just self-explanatory. This we saw in one of the other motions. Again, they were trying to use the phone records in order to determine or identify the vehicle, and that's problematic, right? Yeah, pursuant to Carpenter, to the extent that the information was being gathered for the movements of the vehicle, Mr. Kohberger has a right to privacy protected by both the Fourth Amendment and Article 1, Section 17. Yeah, intentionally omitted information. This is going to be all the same stuff. Lacks particularization. Yep, same stuff. The thing is that with a lot of these motions that have a lot of the same basis, right? They have the same grounds, they're citing the same case law. You can imagine that either you can say that the ones that are substantially similar, right? You would imagine that group, right, would either all be granted, the motions to suppress would be granted, or they will all be denied, right? Because just to reiterate, so much of this is the same. Like, again, they're all the same in the sense that they all go back to the IGG, first of all. But even apart from that, right, a lot of it is the same with their, especially when it comes to like the technology and stuff, it's the same issues. They're citing the same case law. So, they have to make motions for each specific thing, obviously, right? But they're probably going to be treated about the same, I would imagine. All this is the same. Conclusion. Yep. Motion just wants it suppressed, as we know. So, okay, next up, we have the search for his person. In Idaho, I believe, because I think there's two of these. So this is probably DNA, I would imagine. Yeah. Did you catch that question I was asking though about the thing about him not going back the next morning? Like they said that they thought he didn't in the last video, the last live stream. We had read that, but then I just saw that part that I highlighted that they said that the vehicle made a similar trip in the morning. Did you catch that part? Because I don't know what the deal was with that. Because if the phone places him there and the vehicle makes a similar round trip at that time, why would they walk back? Why would law enforcement walk back thinking that he was there? Like, I don't know. Okay, so it's all the same. He was unarmed. Yeah. Okay. Search warrant. Sergeant Blake requested a search warrant for his person, relying upon the same facts articulated above for the warrants used in Pennsylvania. Later that day, right. This is what I figured. His person was searched. So pictures of his bodies, fingerprints, and DNA swab. Buckle swab. There it is. Yep. Again, this is because it's fruit of the poisonous tree. That's why. This was all done going back to in the defense's mind, or in what they're contending were illegal or unconstitutional search and seizures from the beginning, right? So it's all fruit of the poisonous tree. It's either all fruit of the poisonous tree or it's either all not fruit of the poisonous tree, right? That's really what this comes down to. So, okay. And this is probably substantially the same. Let me just see, because this is right. Yeah, this is for his person, but this is in Pennsylvania. So that's going to be the same thing, but just Pennsylvania instead of Idaho. All right, next up, we have the white Hyundai. Oh, boy. Right? Do I have that? Is that what you are? Yep. White Hyundai. Okay. All right. This is going to be interesting. So, not a valid warrant. This is all standard. Okay. Facts of the case here, background that we know. Okay, that's the same. This is the same as what we've seen. Okay, exclusionary rule. We've seen this part too of Professor Kerr. However, it remains to be determined whether the actions of the FBI and Pennsylvania state troops should be viewed through the lens of Article 1, Section 17, or its analogs. It is not at all clear that whether a search should be judged by Idaho's standards of reasonableness or that of Pennsylvania, again, the multi-state issues here, or in the case of the FBI agents by the Fourth Amendment. And we talked about this a lot on the last stream because there's these different standards, right? And the FBI, they have the most lax standard for probable cause to obtain a search warrant. As noted, Professor Kerr would have Idaho's reasonableness apply in that the FBI and the Pennsylvania state troopers were acting under its authorization. This approach would also mesh well with older cases. It also goes along with the legal framework of agency. In this matter, Idaho authorities required assistance from the FBI and the Pennsylvania State Police. Thus, this court should be required to apply Idaho search and seizure laws to their actions in Pennsylvania. However, this concept has its detractors. So I think we saw this before because I remember mentioning they're doing their due diligence here by going ahead and citing the oppositional, case law or arguments that go against their position, which is due diligence. When you're filing a motion, you're supposed to be doing that. Some places or some states require it, but even if it's not required, it's considered best practice. Pennsylvania law enforcement violated Mr. Kohberger's Fourth Amendment rights by entering and searching his vehicle without a valid warrant. Police cannot search a vehicle within the curtilage of a home without a warrant. Now, curtilage, I know yesterday we mentioned in terms of, I was talking about my research I've done into searches, and I was talking about like a domicile, right? Dwelling. I forgot to use the other word that is often used in the case law about this, which is curtilage. So that's like the home and like the surrounding premises of the home, but like it includes the home. Mr. Kohberger's, so like, for example, a garage, right? Remember we were talking about outbuildings yesterday? So like shed, garage, though that counts as the curtilage. So Mr. Kohberger's vehicle was in his parents' garage in a home where he was an overnight guest. Overnight guests have an expectation of privacy in the home where they stay. All right, so establishing that. Therefore, he had an expectation of privacy in the contents of his vehicle, and a warrant was required. Pennsylvania law enforcement search warrant lacked probable cause. This is all the same as what we've seen. The challenge pursuant to this section of the motion is separately laid out in Mr. Kohberger's motion for a hearing under Franks v. Delaware, right? So we don't have all the details, but maybe we will learn if that hearing is public, if they're granted the hearing. IGG again here. Loss is the same. Yeah. Okay. So there's not really anything new learned in that one, but so much as just that the search was, in their eyes, illegal. Okay. So next up, so Pennsylvania search warrant for 119 Lamsden Drive and statements made. All right, including statements made after his arrest. Are we going to hear more about the interrogation? The Idaho arrest warrant could not have given police in Pennsylvania the authority to enter the home. That sounds like a problem, because a lot of these things, there's kind of similar grounds or similar basis for these. This is specific to this particular issue in terms of what happened in Pennsylvania, right? But this whole thing about relying on the Idaho arrest warrant, like, again, if this is legitimate, that's a problem for the state, right? Oh my God, I did not mean to do that. Like a big problem. Can I make that go away? Undo. I don't know. Okay, well, now it looks like that. Oh my God, sorry. All right, well, that is yellow now. So anyway, but yeah, so that's more specific to the whole multi-state issue as well. Federal and Pennsylvania law enforcement violated Mr. Kohberger's Idaho and Pennsylvania constitutional rights by not knocking and announcing their presence and presenting Mr. Kohberger with the opportunity to surrender. Yeah, that's a thing. That's a thing too. Right, row. This is all the same. Okay, now this is different though. The basic facts Blaker used to support the search were: 1, next to the body of Madison Mogan was a tan leather knife sheath. The Idaho State Lab later located a single source of male DNA on the button snap of the knife sheath. 2, footage from the King Road neighborhood showed what the police suspected was the vehicle of the killer. This white sedan lacked a front license plate. A vehicle specialist decided, and that's in scare quotes, decided based on the footage that the vehicle was a 2011 and 2016 Hyundai Elantra. A vehicle matching that description was spotted via surveillance in Pullman. It was later discovered that Mr. Kohberger drives a 2015 Hyundai Elantra and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. This same specialist indicated the car seen in Pullman was a 2014 to 16 Hyundai Elantra. 3, witness Dylan Mortensen had indicated the height of the person she saw at the time of the attack was between 5'10" and 6 feet, had bushy eyebrows. Police determined that Mr. Kohberger fit that description. Number 4, records from, and okay, we've already read that part. They got the license plate number. We know that he changed his vehicle registration. And we this part about this is all the same. We've read the cell phones. So this is, again, the thing I was pointing out before that's weird, right? Because here, right, a similar data showing occurs at approximately 9 a.m. with a trip into Moscow and returning at 9:32 a.m. So that would support that they think he did make that final trip, right? We know that we already saw in that other document that we know the phone was pinging there, right? But yet I was like, that's weird that they were saying that they don't think he made that trip. But then this would support they think he makes the trip, right? So I don't understand the discrepancy there. Here we go. Okay, well, here it is back to back. Okay, let's look at this now, right? The same team determined that Mr. Kohberger had been to Moscow at least 12 occasions prior to the event, that he came to the area the following morning, the morning following the murders. However, law enforcement without explanation indicated did not believe the final trip ever occurred. But then you have this, right? Trying to highlight just the right amount. There we go. Highlighted. Okay, so I don't know. Pennsylvania agencies, garbage. We know about the garbage. Right. Okay. And found DNA determined was likely the father of the suspect DNA found on the sheath. And this is all the same. This is all the same. This is all the same. It's probably going to be the same until we get to the end. Yep, 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 yep. Oh. Oh. Hold on. The interrogation. Okay. Da. Oh my God. Okay. Oh my God. New information, guys. New information. Holy shit. Okay. Okay. All right. Statements after arrest are either fruit of the poisonous tree from the illegal arrest or should be suppressed as a Miranda violation. Oh boy, I'm excited now. Fuck yeah. All right. Any statements post-arrest of Mr. Kohberger are fruit of the poisonous tree from an unlawful arrest. In addition, statements made as soon as he was placed in zip ties and held at gunpoint by many officers without a Miranda warning should be suppressed. Okay, we've talked on this channel a lot about Miranda, and many of you guys are probably pretty aware of how that works. It came up a lot in Sarah Boone. It was talked about quite a bit with that too, because was it Sarah Boone? I think it was Sarah Boone. Just in terms of what is the standard, right? Because, when do they have to read Miranda? And the standard is like when it's a person reasonably would believe that they are being detained. So for example, if you're in a room with law enforcement officers and there's somebody standing and blocking the door, even if they haven't said you're under arrest, even if whatever, it doesn't matter. If it looks like you are being detained in any way and that it's reasonable that this whoever is being talked to would think that or interviewed would think that counts. You need Miranda, okay? So therefore, with that in mind, being placed in zip ties and held at gunpoint, yes. I don't know how this is even being shouldn't this have already been decided? Those statements can't come in. There's no way. Unless they're going to argue they did read Miranda, but it says here without a Miranda warning. So that, yeah. Hold on. Let me take that back because here's the thing. Okay, hold on. Okay, I'm remembering this other factor. The other factor is this. If they didn't ask him any questions, but he just offered things, then this is not going to work for them, for the defense, because right. Okay. So I'm just thinking the word matters here, right? So it doesn't say he was asked questions. It says he made statements. Statements he made after being placed. So he's clearly being in custody, right? But statements he made without a Miranda warning should be suppressed. That's not going to work, because if they didn't ask him anything, any statement, that's how that goes. If you offer and volunteer statements, that's on you. To protect the Fifth Amendment privilege against compulsory self-incrimination, police, quote, must inform individuals of their right to remain silent and their right to counsel, either retained or appointed, before undertaking a custodial interrogation. The requirement for Miranda warnings is triggered by custodial interrogation. So what do we mean by custodial, right? That you're in custody, or it's you could reasonably believe that you're in custody. What do they mean by interrogation? This doesn't just mean sitting in the room being interrogated. Again, that's when they ask you questions. They might get into all this, but I'm just in case they don't. So that it's clear that like custodial interrogation would apply in his case, being placed in zip ties and held at gunpoint, if they were asking him questions. We don't know yet that they were. It sounds like he just offered statements. A person need not be, okay, yeah, here we keep reading. A person need not be under arrest to be in custody for Miranda purposes. Yep. So, all right, here we go. Short of an actual arrest, the safeguards prescribed by Miranda become applicable as soon as a suspect's freedom of action is curtailed to a degree associated with formal arrest. The custody test is an objective one. It is not based on the subjective impressions of the minds of either the defendant or the law enforcement officer. The only relevant inquiry is how a reasonable man, there it is, a reasonable man in the suspect's position would have understood the situation. Bam, that's what I was trying to get at earlier. Custodial interrogation means questioning initiated by law enforcement officers after a person has been taken into custody. Yep, that's what I would, again, keep reading, right? They have to ask you questions. They initiate asking questions. Taken into custody. So again, that would apply for him with the zip ties and whatnot, if they were asking questions, right? So taken into custody or otherwise deprived of his freedom of action in any significant way. Interrogation includes not only express questioning, but also words or actions. This is important. Interrogation includes not only express questioning, but also words or actions that the police should know are reasonably likely to elicit an incriminating response. I don't know why they omitted the citation. So, okay. Mr. Kohberger was zip tied after a no-knock warrant was served. He was zip tied at his hands and surrounded by police at gunpoint. Law enforcement did not Mirandize him immediately. Instead, they waited until after he was transported in a police car, handcuffed with at least 2 officers in the car. One was seated next to him in the back seat. A reasonable person in Mr. Kohberger's position would have right. And that's what I already said, right? I said that exact same thing. I'm like, yep, I think the zip ties, right? Like that point, like zip ties and gunpoint. Yeah, we're in custody there. Yep. Oh, and I just saw what you said here. Yeah. That's a good point. Yeah, that's a good point. Thank you for pointing that out. Need some Z's. So, okay, 2 conversations. Oh boy, oh boy, oh boy, oh boy. 2 conversations took place before Mr. Kohberger was Mirandized at the police station. Now, remember, from what we already know, it sounds like once he was Mirandized at the police station, he did then also talk more. So that would be a total so far of 3 conversations. Okay, so 2 conversations took place before he was Mirandized at the police station. It is clear from the police station video that detectives asked him, okay, so there's a video. Hey, guys, guess what? Now we know. It is clear from the police station video that detectives asked him if he'd ever been Mirandized before and said they needed to go through the formality of Mirandizing him. He said no. Uh-oh. No video. Hold on. Okay, no video or audio recording of the entry into the home. An initial request has been produced, initial arrest has been produced. Video and audio begin with him in the car. I'm sure we're going to learn specifically that interrogation if it was filmed. But having said that, I have high hopes because of this part. There's a police station video, so that's good news. In determining whether a person has been subjected to custodial interrogation for purposes of Miranda, courts may also consider, quote, the conduct of the officers and the nature and manner of the questioning, end quote. The conduct of law enforcement with Mr. Kohberger in the house is referred to as small talk when he's being recorded during transport. This cannot be verified because no audio or video is produced. The conduct of the officer in the police car during transport cannot be described as an interrogation. In other words, the way they were asking him questions or chatting with him wouldn't count as that. However, without a video or audio recording of in-custody discussions inside the house, the true nature of the statements made in the car are without context. All statements made at the police station were post-Miranda. Okay, so that's what I thought, right? So that's so crazy, right? Dude, they Mirandized him and he said, yep, I'll talk. What the hell? That blows my mind. Because you guys know, we've said it on this channel a million times, never do it. Never do it. You need one word. That word is attorney. Because once you say that, they're like, well, we don't care anymore. So I cannot believe that he did that. This is shocking to me. Oh my God. Ugh. Information in the media right after the arrest and attributed to law enforcement report that Mr. Kohberger something. So this is the thing that I was referencing, right? That I said something about, there was a rumor that he had said something, but I don't think we even ever heard what the statement was. Do you guys remember? I don't think we even heard what it was. It was just he said something, right? But like, again, for me, I'm like, well, I'll believe it when there's proof of that, right? Because that was just a rumor. So it says information in the media right after the arrest attributed to law enforcement report that Mr. Kohberger something. Such a statement is not, so it's not legitimate. Such a statement is not in a police report or in an audio video recording that can be found in discovery. If it is a statement that the state will seek to attribute to him at trial, it should be suppressed as a non-Mirandized statement. So they're saying if that statement actually happened, because so far there's no record that this statement did happen, whatever it was. But if it did happen, it should be suppressed. In the conversation with if the conversation with Mr. Kohberger inside the house was custodial in nature, that context may warrant suppression of the conversation with police in the police car during transport. This is very interesting. So far, what they've not done is they've not said, hey, the statement's made. Well, hold on. They said it in one of the other documents. Okay, here's what I think they're saying. Here's what I think is going on here. I don't think that they're saying that the interrogation needs to be thrown out because of some problem done by law, because that happens a lot, right? Typically, it's like they ask for an attorney, but then they're questioned further, or their Miranda rights are violated. In this case, it sounds like the interrogation was done above board in the sense that he was Mirandized, he agreed to talk, he made statements, and then at some point he asked for an attorney, and then that was it. So from what we've seen so far, their grounds for trying to say that this interrogation and all of these statements should be suppressed is really more coming from this fruit of the poisonous tree argument, hence with the IGG. And that's a really important distinction to make, right? Again, I want to repeat that. It looks like they don't have grounds to suppress the interrogation, or they've not filed that yet. It could be coming, right? But they've not filed it yet. And within the slew of these motions to suppress, they haven't filed that in terms of they haven't said that, they didn't say that interrogation that his rights were violated. Now, they did reference statements made before he was Mirandized. So that would refer to the statements made in the car, I believe, right? Which they just talked about here. But they've not said anything. They've not said the interrogation needs to be thrown out on its own merit with Miranda. Their only argument is, so far, it looks like, is just simply this fruit of the poisonous tree because they got to him through the IDG, and they didn't have a valid warrant for that. There was issues with the warrants. Again, I don't know why we're not hearing more about the trash issue, right? Because again, to me, it's like, if that was private property, that to me should be that I keep thinking this, right? It's like, that looks like that's the case. But if that was the case, that would be the first thing you would do as his defense attorney. And the case would have been thrown out. I mean, because that's just clear cut. But we'll see if there's overlap between that and the warrant, right? Because it's like, well, they should have had, again, because if it was on private property, which it looks like it was, they need a warrant to go in there and dig through that trash, which is how they got the DNA from his dad, and then the rest we guys already know. So the conversations in the car were recorded. We know there was activity at the police station that was recorded. So far, the only thing that it doesn't have audio or video is any conversations had at the parents' house when they at the parents' house when they zip tied him and put him in handcuffs or taught whatever went down at the house was not video or audio recorded. But so far we know they've confirmed that the chatting in the car was, and then at the very least, them getting at the police station, there's video and audio of that, but they didn't specifically say if that continued into the interrogation. So that's something we can keep an eye out for. They failed to knock before raiding the home. The warrant lacks probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusions, and because the warrant omitted exculpatory information and information that put into question the reliability of the facts which it lies. So and then this is what I was saying, right? Any statements made by Mr. Kohberger are fruit of the poisonous tree of the illegal arrest. That's my point, right? So in other words, that's how they're going to try to get rid of the interrogation video, if that exists, is this. Again, it's the fruit of the poisonous tree, because it doesn't look like anything, like law enforcement didn't violate his rights in terms of the interrogation itself, right? That was all done above board, it looks like. And so that's why they're making this argument. Some statements may also be excludable under Miranda. So that's saying because they don't know about the statements made at the house. I think that's what that's referencing. Okay, next up. We're almost done. Woo! All right, last thing here. And there will be a slew of responses. I will keep an eye out as always. We know at the very least, it looks like there should be a motion coming in any day from the defense. I forget what that was about, but that was, I think, at the beginning of the stream. They said there's going to be another filing about something, and that hasn't come out yet. So that might be happening today at some point. But even apart from that, we should be seeing responses from the state and then orders from the judge and other things. So, okay. So this is the order, the order denying the motion for leave. So remember, the very first document we covered yesterday was the motion for leave. And remember what I pointed out? I said, look at the date, guys, look at the date, because it was filed on November 13th, and the deadline for the discovery was November 14th. So what is Judge Hippler going to say? Before the court is defendant's Before the court is defendant's naked motion for leave, November 13th, in which he seeks relief from the discovery motions deadline of November 14th as set forth in the governing scheduling order. Defendant asserts his counsel and investigators are still reviewing the vast amount of discovery in this case, and therefore needs additional time to file motions related to discovery. Motions to enlarge a deadline filed on the eve of the deadline are not well taken. He's not happy with the defense counsel. The state's discovery deadline was September 6th. The defendant could have ascertained far sooner whether the discovery motions deadline would pose a difficulty and brought it to the court's attention. Further, and more importantly, defendant has not demonstrated with his filing good cause to enlarge the deadline. He has not set forth what efforts have been made to review the discovery, what portion of discovery has not been reviewed, why it has not been reviewed, or how long it will take to complete such review. Consequently, his motion is denied. So what I'm curious about is then what? Because it would stand to reason, guys, if we take a look at this. Check it out. It would stand to reason, right? Look at all of these that were filed. Now, of course, it says the 14th, right? But I believe, well, let me just take a look. Yeah. Okay. So these say the 14th. They were all filed with the court on the 13th and just posted on the 14th. So in other words, remember, their deadline was the 14th. All this came in on the 13th, even though it says the 14th. All these motions. These are the discovery motions. Okay. So why am I pointing that out? Because this is important. They filed those because of this discovery motions deadline of November 14th. So what this does to me is that he did not grant them leave, which to me means this. Unless they can demonstrate good cause, and they'd have to have a whole separate hearing about this probably and get him to, take another look. In other words, if he stands by this or this motion being denied, That's it. Like what we see here, that's it. So remember when I referenced and I just referenced it actually, that there was supposed to be a subsequent or contemporaneous filing from the defense about some other motion that they were doing, and they referenced it earlier. And I was like, oh, I don't see it yet. I wonder if I'm not seeing it because they missed their deadline. They missed their deadline. Now, again, this is the thing where we know that in a criminal trial, right? Okay. So then there's like discovery violations, right? But we know in a criminal trial, everything is about protecting the defendant's rights. And typically, they don't want to cause issues for appeal. They don't want to violate those rights. So I know that it's possible, right? And it would depend on the judge that you could, again, if you can show good cause, they can, have him take another look. Potentially, maybe he'll say, okay, you can have another however long and change that date, right? And then we could see more motions coming. But if he sticks by what he said, this is it in terms of the discovery motions. So in other words, this is it on the motions to suppress. And whatever else they were going to get in, they can't get in. And that's just really hard to wrap my head around because I can't imagine them being put in. Like, you see how that just was, I can just imagine that being like such a fairness issue, right? Like that they were going to have more motions and I feel like that never happens. I feel like they are always allowed in, right? Now, if this was the state, there would be some sort of sanction, but I don't know that this would happen in this case for the defense counsel. Because if you sanction them, you're like punishing the defendant, right? So, and again, the state has all the resources, the defense doesn't, the defense is at every disadvantage and that's the rights that they have to protect. So I would be, I guess if I think it through, I would be surprised if, here's what I think will happen. What I think will happen is we will probably see, okay, more filings coming in regarding this deadline where they're asking to have a hearing, maybe an in-camera hearing or whatever, but I feel like the defense cannot be happy with that because they have more motions they were going to file, right? So we don't know how many, but if you think about, they're defending their client, right? He's innocent until proven guilty. And whether it's one motion or 20 more motions or whatever, that is a huge problem if that can't be filed. So I think what we will see something happen here where they're going to be able to still file these things, but it might be that they need to have a schedule a hearing and there could be some hullabaloo first, right? We'll see. The motion for leave. I don't think so. Discovery motions. It's a discovery motion deadline. There's no deadline to review discovery because you're always going to be reviewing discovery even throughout trial, right? That's an ongoing process. The deadline is for filing motions, right? Discovery motions deadlines. That's why I pointed out this. These are discovery motions because what are they suppressing? They're suppressing discovery. All this is discovery, right? This is all discovery. These are discovery motions to suppress. That's what that is. So when it says, now there's other types of discovery motions, not just motions to suppress, but this is in that category, right? Let me pull up. So discovery motions would be motions to suppress or motions to dismiss. Now, we had a lot of motions to dismiss, especially in relation to the death penalty, motions to suppress and motions to suppress and to dismiss. That's what it is. So this, again, back to here, this motion for leave is related to discovery motions deadlines. That's filing. A motion is like y'all know, right? A motion, they're moving, the party is moving. In this case, the defense is moving. They're asking the court to do something. They're moving. So in this case, it's to suppress, right? That's a discovery motion. That's the deadline is to have that filed with the court. Okay. And what they're saying is they haven't finished a full review. So this is maybe why there was some confusion. They have not finished a full review. The reason that matters is because then they can write their motions, right? The problem isn't that the problem here is that because they haven't finished their full review, they're saying they haven't had enough time to then file other motions, whether it's motions to suppress or motions to dismiss. They have to first review the discovery. And again, it's an ongoing process. They'll continue to review it, right? But what they're saying is they haven't finished reviewing all of it the first time around, right? And again, it even says, we'll continue to do so, even says, continue to do so. So the deadline isn't to review it. The deadline is to review it and then file the subsequent motions, okay? So then, see, seeks relief from the discovery motions deadline. And it even says here, spells it out. There it is, yeah. Defendant asserts his counsel investigators are still reviewing the vast amount of discovery in this case and therefore needs additional time to file motions related to discovery. File motions related to discovery. So you guys see what I mean? So they have other motions they would be filing. And there's at least one that was already in the works because they referenced it already. So that's what I'm saying to me. It's like, I can't imagine that they've got these other motions that they would be filing, but they're not allowed to. Like I feel like that just wouldn't happen in a criminal case, you know, when it's coming from the defense side, right? Again, the prosecution would be held to those deadlines and face sanctions. As we know, for example, in Lori Vallow's case, because the state missed a discovery deadline there, the sanction and the way they worked that out was they took the death penalty off the table. Because again, it's all about fairness to the defendant. And because of that, right, in the interest of justice, right, and being fair to the defendant who's innocent to proven guilty, I would be shocked if they are not allowed to file subsequent motions. That just sounds like such a big problem. Like I can't even fathom that happening. So I would imagine, again, back to what I was saying, I would imagine that we will see some other things coming up here on the docket. And, you know, whether it's written, you know, in writing, or they're going to ask to have a hearing. But I would imagine they're going to get those other motions. And otherwise, that just seems like you expect the case, if he's convicted, to be overturned on appeal. I mean, I just can't fathom it. So, yeah. And that's true. And while that might be true, I think the problem here, and from the judge's perspective, okay, is this. From the judge's perspective, it's because it was on the eve of the deadline. And we know this. We've seen this in other cases right here. This is his point. He's mad. This is a judge-specific thing, right? Some judges would handle this differently. He's clearly a stickler, Judge Stickler, right? What did I call him before? Judge Grinchler. His name is Judge Hippler, but he's a stickler and like the Grinch. So motions to enlarge a deadline filed on the eve of the deadline are not well taken. So that is it right there. So that's him saying, if you'd asked earlier, I would have granted it. That's him saying, because you did it on the eve, the night before, that's not cool, you know? And what it's saying is that also, additionally, it's saying that they didn't actually set forth what yet hasn't been reviewed or how much time they would need. But you know what? I feel like even if they had, I still think my read on this judge would be that even if they'd included the other information, filing it on the eve of the deadline, I feel like he would have still denied it. And there's a footnote here. This order does not foreclose discovery motions pertaining to new or supplemental discovery responses, or in the event new information comes to light. There we go. What was I saying? Remember when I was like, I know there's going to be some sort of exception where they're going to be able to get around because they can't be treated right here. This order does not foreclose discovery motions pertaining to new or supplemental discovery responses, or in the event new information comes to light requiring additional discovery motions. That's that whole thing. Like I said, remember when I was like, you know, there's a potential that they can talk to him and then this could change and he'll grant them that motion for leave and of the deadline, and you know, they'll figure out how long to push it out or whatever. So there you go. There you go. I would expect that to happen. You do like Kipler? That's interesting. I don't so far, but honestly, I don't remember. Maybe. I would go back and look, but there's like 5 trillion court filings, and you'd have to open them up to see. They may have, I don't know. But again, like I said, this depends on the judge, because some judges wouldn't be as bothered, but Judge Hippler is that type of judge. So. Well, okay, so Needson's saying, so he's not stopping them from filing motions and stuff they haven't reviewed. I don't think that's not what that says. What this is saying, let me just make a distinction here. Yes and no. What this is saying is information that hasn't come in yet, right? So in other words, for example, remember how we learned that the defendant's 4th and 5th motions to compel, there's still some discovery the state hasn't turned over. That's a perfect example. We learned about that. So they don't have that discovery yet because the state hasn't turned it over. That would be supplemental discovery, newer supplemental discovery. That's what that is referencing, okay? They don't have it yet. However, in regards to discovery they have already but haven't reviewed yet, what pertains to that is this part. New information comes to light requiring additional discovery motions. And what could that new information be? I'm just guessing here that like it could be, well, we just learned this thing because in other words, I could see this applying to the discovery they have but haven't reviewed, because when they review it, it's new information. In other words, it's not new discovery, right? It's discovery they already have, but the information would be new to them because they haven't discovered it yet. They haven't read it yet or reviewed it, if that makes any sense. So like, in other words, if there's this pile of discovery, they haven't gone through it, and then they go through it, and now this information is new to them, right? That could pertain to this bottom half of this footnote here, where it says new information comes to light requiring additional discovery motions. That, I think, is their window to still get stuff in. Whereas the first part of that footnote is stuff that hasn't been turned over. So hopefully that makes sense. It's all good. I'm a teacher by nature, and that's what I do. So whether it's for anybody else or even just for my own edification, it's always a great opportunity to just make that distinction, because it's important. This stuff matters, right? And it can be kind of complicated. So it's always, whenever there's an opportunity to make a clarification about how this works, I'm always going to be happy to do that. So that finishes it. So I have a video. I haven't uploaded it yet to YouTube. I'm going to do that after this stream. I made a video from the latest Karen Reed hearing, and it's, I was streaming that live at the time. EDB was streaming it live at the time, and then Laura did a recap, whatever, later that day or whatever, and then subsequently a few days later, Law and Lumber was talking about it. So I put together, as I've done before with other things, a little video of like me and EDB and Laura, and Rob and Runkle, on Friday Night Frenzy, and just like highlights of the trial, but like things that were funny because of how we would have, some of us, like sometimes it was like the exact same response, or like saying the same things, or I don't know. It was just and there were some funny moments, right? But it was also a really interesting hearing. Like I thought that hearing was a great hearing. I loved it. And we learned a lot. And so that full hearing, of course, you can see that on the playlist for Karen Reed, but I'm also going to have that video coming out with just those different clips of everybody commenting on it. And then tonight we have the next Casey Anthony episode, and this one is taking a break from the trial testimony, and we are going to review the Orange County Sheriff's Office investigative report written by Detective Yuri Melik, who we heard from early in the trial. He's also the one who interrogated Casey at Universal Studios. He wrote that report. I stumbled upon that by accident, and it was a great accident to come across it. And I was like, oh boy, let's read this. So we're going to take an episode to read that and go through it. And it's basically going to be outlining, it's their investigative report. It's literally outlining all of the law enforcement's findings, and that's literally what the state is basing their entire case on. So this will be interesting to see what's in there. So anyway, but thanks everybody for being here. I will keep an eye out as always for the next documents that come in, and see y'all hopefully tonight for the Casey Anthony investigative report, and if not, hopefully soon. Thanks for being here and being a squirrel. See y'all next time.